Our speaker tonight comes from very close to Boston because he's a professor of law at Harvard University. And it's a great pleasure for me to introduce Randall Kennedy. Randy Kennedy and I were students together in Oxford in 1977, 78, and 79. And I can tell you that the average age in this room, if you absent the faculty, is probably about 17. And if you take 17 and double it to get to 34, that's the length of time since he and I last saw each other, which is really quite remarkable. And it's a very special occasion for me, Randy, to welcome you here and to say how good it is to see you again. Thank you for coming. I'll tell you just a little bit more quickly about Randall Kennedy. He did his BA at Princeton University, then went on to Oxford in England, has a JD from Yale University, and has been a professor at the Harvard Law School since 1984. That's a long time. And he is the Michael R. Klein Professor of Law at Harvard. Apart from being somebody who's deeply steeped in and versed in the law, Randall Kennedy is a writer of note and a thinker, and I would certainly say a philosopher. He's written a great deal about language, about politics, about law, and interrelated matters. His most recent publication, not yet out, his most recent book, coming out in September, is called For Discrimination, Race, Affirmative Action, and the Law. It's a topic which is no doubt topical and controversial, and he's going to present to us this evening an excerpt from that book. And I hope that you will be stimulated by it. I hope that you will be asking questions at the end, and I hope that we'll have some exciting questions. And the title of his talk tonight is Colorblindness in American Life and Law. Randy, it's wonderful to have you here. Thank you very much, and over to you.
Well, thank you very much for the gracious introduction, and even more for facilitating this, this gathering and for giving me this platform, allowing me a few minutes to talk with colleagues and students. I'm going to speak for a few minutes about a very important term in American life and law. That term is colorblindness. It's a key term in American political discourse. It's probably the most popular conception of what is thought to be commendable racial thought and conduct. What do I mean by that? I mean by that, if you were to go around and just ask people, what do you want, you know, in terms of race in America? What are you seeking to create? If you ask the President of the United States, what sort of racial regime would you want in the United States? I bet there's he would probably say something about colorblindness. And certainly if you were to ask people in the House of Representatives or the Senate, if you were to ask editors of magazines or newspapers, many of these people, many of the sort of leading arbiters of opinion would talk about colorblindness. Now, what does colorblindness stand for? Colorblindness stands for the proposition that race ought to play no role in assessing individuals, that race ought to be absent from any calculation determining whether a person is detained by police, or sent to prison, or tapped for a promotion, or picked for an orchestra, or chosen for jury service, or selected by a university. Race ought to play no role in assessing universities, in assessing a person. I think that's basically what people mean by colorblindness. Now, there's two sorts of folks who embrace colorblindness. One set are people who I'm going to call colorblindness gradualists. These are people who associate themselves with Justice Harry Blackmun. Justice Harry Blackmun was a very distinguished member of the Supreme Court of the United States, and he said the following: in order to get beyond racism, we must first take race into account. So he said, I ultimately want to live in a colorblind America, but before we can live in a colorblind America, we've got to take race into account through things like affirmative action. So I want to get to a colorblind America, but we're going to have to get to it over time. We're really not ready to get to it right now. So you've got people who are colorblindness gradualists. Then you've got other people who are what I call colorblind immediatists. They insist that in order to make race irrelevant, one must make it irrelevant now. So the Chief Justice of the Supreme Court, Chief Justice John Roberts, he has this belief. And he reflected this belief when he said in a recent Supreme Court decision, the way to stop discrimination on the basis of race is to stop discrimination on the basis of race. Now his position is, let's just get rid of race right now, cold turkey. Or, I'm going to quote another colorblindness immediatist, a professor, colleague, a guy by the name of William Van Alstyne, and he put it this way: one gets beyond racism by getting beyond it now, by a complete, resolute, incredible commitment never to tolerate in one's own life or in the life or practices of one's government the differential treatment of other human beings by race. That, according to Van Alstyne, is the great lesson for government itself to teach. In all we do in life, whatever we do in life, to treat any person less well than another, or to favor any more than another for being black or white or brown or red, is wrong. Now, in the next few minutes, I want to take the measure of this idea of colorblindness, especially as it relates to affirmative action, the idea of giving a preference, giving a boost to historically disadvantaged racial minorities. I want to take the measure of affirmative action, of colorblindness, by charting its history, noting its attraction, and positing its weaknesses. And I'm going to come to a conclusion, and I'll give you the conclusion now. My conclusion is that as an aspiration and as a strategy, colorblindness is misconceived. I'm against the idea of colorblindness. That's my conclusion. But we've got a few steps to go to before we get to that. So first, a little bit of history. The single most widely cited statement associated with the idea of colorblindness is a declaration by Justice John Marshall Harlan. John Marshall Harlan said this in 1896. In respect of civil rights common to all citizens, the Constitution of the United States does not permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. Harlan made this statement in dissenting from the Supreme Court's ruling in a notorious case, Plessy versus Ferguson. This was a case in which the Supreme Court of the United States upheld the constitutionality of a Louisiana law that required passengers of different races to occupy equal but separate cars on trains. The court concluded that the compulsory racial separation was reasonable in light of custom and public opinion. Harlan, by contrast, saw the law as a stigmatizing brand inflicted on black people and thought it was unconstitutional. And in the course of saying why he thought it was unconstitutional, he said, in his view, the Constitution of the United States is colorblind. Now, Harlan's assertion that government ought not be allowed to make racial distinctions in the enjoyment of civil rights stemmed in part from a resilient but marginalized strand of thought and feeling in 19th century America. Contributors to this tradition included the women dissidents who petitioned the Massachusetts legislature in 1839 to repeal all laws which make any distinction on account of color. Another contributor to this tradition was the great Charles Sumner, a senator from Massachusetts, an alumnus of Harvard Law School, who, in attacking racial segregation in the Boston public schools, maintained that any and all racial distinctions amounted to unacceptable manifestations of caste. More immediately, Justice Harlan's evocation of the colorblind Constitution echoed the brief of the losing lawyer in Plessy versus Ferguson, a man by the name of Albion Tourget. Albion Tourget remarked that justice is pictured blind and her daughter, the law, ought at least to be colorblind. Condensing that language, Justice Harlan made it more memorable. But notice a couple of things. Justice Harlan offered no historical or textual support for his claim that our Constitution is colorblind. And he said, that's what I think the Constitution should be interpreted as. The Constitution should be interpreted as colorblind. But he didn't give any support for that. That was his view. He didn't give any support for that. And there's reason for him not giving support for it, and one reason for him not giving support for it is that there's frankly very little support to give. The congressional framers of the 14th Amendment expressly declined to accept language that would have explicitly prohibited the government from drawing racial lines. Wendell Phillips, a great abolitionist, proposed that the 14th Amendment should say, no state shall make any distinction in civil rights and privileges on account of race, color, or descent. If that language had been adopted, we would have had a constitution that would have explicitly said no to any sort of racial distinctions. But that proposal was not adopted. It was rejected. And it was rejected in favor of a standard that is open-ended and that says nothing about racial distinctions. The Equal Protection Clause of the United States Constitution simply says that states must provide the equal protection of the law to all persons. There's nothing in that statement about racial distinctions whatsoever. It just talks about the equal protection of the law, whatever that is. Moreover, many of the framers and ratifiers of the 14th Amendment countenanced laws that explicitly differentiated people on a racial basis. So if you go back to 1868 and see what sort of laws was Congress passing, Congress is passing all sorts of laws that made racial distinctions. Some of these laws had special provisions for people of color, in particular, the newly freed black slaves, or the newly freed people who had been slaves. Congress and the states also had other laws. There were laws passed that segregated people on a racial basis. Many states in the 1860s, the 1870s, the 1880s, up until midway in the 20th century, prohibited people of different races from marrying. So in the 1860s, when the 14th Amendment was promulgated, there were many laws that were embraced by the very people who framed the 14th Amendment that nonetheless countenanced racial distinctions. Now, so there was nothing in the text of the Constitution that explicitly prohibited racial distinctions. The framers of the 14th Amendment, at least many of them, embraced various sorts of racial distinctions. Now, there's something else about Harlan's famous statement. I stay on this a little bit because Harlan's statement, our Constitution is colorblind, it's a very famous statement. It's one of the few statements that I would suppose every law student would be expected to know. I would bet that many of you in your American history courses bump up into Harlan's statement when you talk about the period after Reconstruction, after the fall of Reconstruction. There's one other thing about Harlan's statement that's often overlooked, but I want to mention it. Harlan's statement that our Constitution is colorblind is often quoted. There is another part of Harlan's dissent, however, that is often overlooked, but I want to bring it to our attention. Harlan says the following in his dissent: "The white race deems itself to be the dominant race in this country, and so it is, in prestige and achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty." A lot of people, if you go to a lot of constitutional law case books, that particular part of the Harlan dissent is just dropped, it's left out, it's omitted. What Harlan seems to be saying was that to remain ascendant, the dominant race did not need to resort to ruses like equal but separate, precisely because it was dominant and would continue to be for all time if it observed the principles of constitutional liberty. These principles, he suggested, pose no real threat to white supremacy. Under the new regime of the 13th, 14th, and 15th Amendments, white supremacy in American society could continue unabated, albeit in a new form. This reading of Justice Harlan's colorblindness declaration comports realistically with the historical, as opposed to the romanticized Justice Harlan. After all, he was a former slave owner, initially opposed the 13th Amendment, which abolished slavery, and tolerated various forms of segregation, notwithstanding his dissent in Plessy versus Ferguson. Now, subsequent to 1896, this Harlan Declaration, our Constitution is colorblind, for many years you didn't see this declaration in the opinions of the Supreme Court of the United States. In fact, you didn't see it, period, not one time, from 1896 until 1961. It was mentioned very briefly in an opinion in 1961 by Justice William Douglas. And then you didn't see it from 1961 until the 1970s. The next time you see this talk about our Constitution being colorblind, you see it in the 1970s and the 1980s. And you see it being used by justices attacking public policies that were aimed at assisting, boosting racial minorities that had been historically disadvantaged. Latinos, but particularly Black Americans. And now, in the Supreme Court of the United States, when you encounter this dissent from Justice Harlan, it is typically used by justices who are attacking affirmative action. Well, in truncated form, that's a little bit of the history of the notion of color blindness. In question and answer, we can unpack that a little bit more if you want. But let me go to a second topic. And that is the question of the attractiveness of color blindness. I would be willing to bet, maybe I'm wrong, but I would be willing to bet some good money that many people in this audience, if you just ask, what do you want in terms of race in America? What sort of racial regime do you want in America? I would bet that many of you would say, well, I want a colorblind America. And colorblindness, like I said at the outset, is a popular conception of a correct racial view. And there's a good reason for that being so popular. Now, I've already told you that I'm against it, but I'm going to come to that later. But I want to say right now, I recognize that it's very popular, and there's a reason for it being popular. Why? Why is it popular? Why do a lot of people embrace the idea of colorblindness? It has several important attractions. One very important attraction is that it offers a clear rule. Disregard race altogether in assessing people. That's a very clear rule. You can state it in one sentence. It's vivid, it's succinct, it's simple, therefore it enjoys the bumper sticker advantage. That's a great advantage for an idea. That's a great advantage for an idea. It's understandable to all, and it's amenable to accountability. Furthermore, it appears to promise a clean break with a long and ugly practice. After all, for most of American history, American life has been scarred, has been disfigured by racial distinctions. Racial slavery, racial segregation. I remember racial segregation. I clearly remember going to the movie theater in Columbia, South Carolina, going to see The Nutty Professor. Jerry Lewis is The Nutty Professor. And going to see it, and I went where other black people went, and there was a sign, colored here, and you'd go to the top of the theater, and the white people went to the bottom of the theater. I clearly remember that. I was 8 years old. Actually, I thought it was great. Sincerely, when I was 8 years old, and when I was 8 years old, I'm from Columbia, South Carolina. I spent my summers in Columbia, South Carolina. When I was 8 years old, I thought that the United States was basically divided into two teams. Really? I thought there was a white team, and I thought there was a black team. And the reason why I thought that is because where I lived, where my aunt lived, there was a chain in the middle of the road. On one side of the chain was the white neighborhood, and on one side of the chain was the black neighborhood. And if I went on the white side of the neighborhood to a store, I thought it was perfectly okay for the white boys to beat me up. And when I say okay, I thought it was, within the rules of the game. And on the other hand, if the white boys were on our side of the chain, we'd beat the hell out of them. And when I went to the movie theater, I thought that, black people had a strategic advantage because after all, we were in the balcony, and it was much easier to throw stuff over than to have the stuff thrown, backwards. That was segregation, and black people and white people went to different schools. The white people went to, let's say, Robert E. Lee, and the black people went to, let's say, Booker T. Washington. And that's just, that was the way it was, especially in the Deep South, but not just in the Deep South, in many places. So colorblindness, appears to, promise a clean break with those sort of practices. And a lot of people, for good reason, were appalled, disgusted with segregation and all that entailed. And so colorblindness, let's turn the page, let's get away from that. Colorblindness is also attractive because it offers the allure of heroic associations, at least until the 1970s. I mentioned before, I mentioned the women in Massachusetts in 1839 petitioning the legislature of Massachusetts to get rid of racial distinctions. The first time the term colorblindness appears in a racial context in the pages of the New York Times, December 26, 1942. First time the colorblindness appears in the New York Times in a racial context. I'm going to read you one paragraph from that news story, and it'll give you a reason why for many, many people, colorblindness is very attractive. Here's a quote from that story. Complete social, political, and economic emancipation for the Negro in a world that is seeking true democracy was advocated here in Black Mountain, North Carolina, by the Fellowship of Southern Churchmen in a statement which calls upon all followers of democracy and Christianity to become colorblind. This is in the middle of World War II. And these people got together in North Carolina and said, we're in favor of colorblindness. That was a very heroic, avant-garde position to take in 1942 in America. That was a revolutionary position to take, certainly in North Carolina. And throughout the 1950s and 1960s, many of the leading figures of the civil rights revolution, including my old boss, the great Thurgood Marshall, Mr. Civil Rights, the first black Supreme Court justice, over and over and over again in the 1950s. What do you want, Justice Marshall? Or again, Attorney Thurgood Marshall, what do you want? And what are you seeking? Colorblindness. So a lot of people say, well, you know, Thurgood Marshall, it's good for Thurgood Marshall, it's good for me. He wasn't alone. There were many people in the 1950s and the 1960s who in conversations, who in editorials, who in sermons, who in lectures talked about the virtue of colorblindness. There are other things that make colorblindness rather attractive to people. I'll just mention one more, one other thing that makes colorblindness attractive. A healthy skepticism regarding the ability of individuals and institutions to distinguish between various sorts of racial distinctions. After all, leading 20th century jurists, I think of Oliver Wendell Holmes Jr., I think of Louis Brandeis, I think of Benjamin Cardozo. Those are three of the leading, most esteemed justices of the Supreme Court in the 20th century, who did not recognize the evil of racial segregation. These are three of the leading lights of the law. Did not recognize the evil of racial segregation. Well, let me give another example. Let me go to a case, Korematsu versus the United States. Korematsu versus the United States was a case decided in 1944. The Supreme Court of the United States upheld a series of laws that placed under curfew and ultimately required not just under curfew, but a series of laws placed under curfew and then imposed detention on all people of Japanese ancestry in the United States, whether they were citizens of the United States or not. The Supreme Court of the United States said that's okay in 1944. That was constitutional. Some of the leading civil libertarians, the person who wrote Korematsu was Justice Hugo Black. The Attorney General of California, who embraced the internment of all people of Japanese ancestry, was Earl Warren, who later became a crusading liberal justice of the Supreme Court. So in light of segregation, in light of Korematsu versus the United States, you could take the position, for some reason in the United States, we can't trust ourselves to deploy racial lines responsibly. We just can't. History has shown us that if we try to do that, we're just not going to be capable of doing it. We're going to make a mess of it. And so, instead of letting ourselves make a mess of it, one position might be, well, let's just get rid of it altogether. We know that we have oppressed people using race lines in the past. So since we know that we've oppressed people using race lines in the past, let's just do away with racial lines altogether. And therefore, if we do away with race lines altogether, we can't misuse them. So as a prophylactic measure, we'll just get rid of race lines altogether. There's a certain logic to that. That sort of, makes sense. Let's go to my third topic, problems with colorblindness. And let's start with this last point. Let's just get rid of color lines altogether, and if we do, we can't misuse them. One problem with that proposition is that few people who embrace the idea of getting rid of the color line altogether are actually committed to that idea. Very, very, very few people. Most have a much narrower conception of that. So in the Supreme Court of the United States, the people who say that they're colorblindness folk, they believe the Constitution is colorblind. Justice Antonin Scalia says all the time, I believe the Constitution is colorblind. Justice Clarence Thomas, I believe the Constitution is colorblind. Justice Alito, I believe that the Constitution is colorblind. Justice Kennedy, I believe that the Constitution is colorblind. They say that. But then push them a little. Push them a little. Do you really believe that? Do you really believe that? In all instances, in all cases? Do you really believe that we should never be able to use racial distinctions? Well, one good thing about the law, one of its attractions, is that in the law there are cases. And these cases put general ideas to the test. So a number of years ago, there was a case that arose. It was a case called Johnson versus California. And what happened was, authorities in California, if you went to prison, for the first several weeks that you were in a California prison, you were put in prison on a racially segregated basis. So if you went to a California prison, the white prisoners went to a part of the prison where white prisoners were. Black prisoners went to a part of the prison where black prisoners were. Latino prisoners went to a part of the prison where Latino prisoners were. Asian Americans went to a part of the prison where Asian people went. And the prison authorities said that they were going to do this. Their justification for doing this was that there are gangs in prison, very violent gangs. And if people of different races were mixed together, people would be hurt by these gangs. And so for purposes of protecting the prisoners, the authorities in California wanted to racially separate them. Well, this became a court case. Goes up to the Supreme Court of the United States, and the Supreme Court of the United States said, we understand, California authorities, what you have in mind, but if you're going to separate people, you've got to have real good reasons for doing this. And in any event, we're not going to let you just separate people like this without your jumping through the hoops that government officials have to jump through in any other context. There were two people on the Supreme Court of the United States who dissented. Who were those two people? Justice Scalia and Justice Thomas. Now, these are the two people, more than any others, who say that they are in favor of the idea of the colorblind Constitution. They embrace Justice Harlan's, our Constitution is colorblind. What did they say in this case? They said, well, this is prison. This is a matter of safety. There is good reason for the prison officials to separate people on a racial basis, at least initially. To tell you the truth, Justice Scalia and Justice Thomas have a good argument. I think that there is, it's not nonsensical what the California authorities were up to. They had a reason for wanting to separate the prisoners on a racial basis. That's not a stupid idea. It's not a silly idea. It might be a good idea. But it is not consistent with the idea that we don't make racial distinctions. And there are other contexts in which the government officials make racial distinctions. And some of the people who say that they're, our Constitution is colorblind, their position is, generally speaking, I'm against racial distinctions, except when they're necessary. Except when they're necessary. Well, remember the first thing I said, one of the first things I said was one of the attractions of the colorblindness idea was it's simple, it's transparent, it's easy. But once you start talking about, well, I'm against racial distinctions except when it's necessary, now we're into line drawing. Now we're into balancing. Now it's messy. One of the attractions of the colorblind Constitution is gone. I said that one of the attractions of the idea of the colorblind Constitution was that in previous times, not only in previous times, but today, because there are a lot of good people who embrace the idea of the colorblind Constitution. I'm against it for reasons that I'll get to in just 1 minute. But there are many people who I admire who embrace the idea of the colorblind Constitution. And there are many people in American history who have embraced the idea of the colorblind Constitution. And that's one of its attractions. Good people. Remember the thing I read from 1942 in North Carolina? Those people. Good people. One thing that should also be remembered, however, is that there are other people who are not committed to any decent idea of racial equality, who use the idea of the colorblind Constitution strategically and opportunistically to attack public policies aimed at elevating racial minorities who've been historically disadvantaged. Now, in settings like this from time to time, people leave it at that. There are some people, and they don't fill in names. But I'm going to fill in some names. Of people who I think have been racist, and I use that word advisedly. I'm not using it in any, I would be prepared to defend my allegation. I'll mention two in particular. Senator Sam Ervin. Senator Sam Ervin, for some people in this room of a certain age, will remember Sam Ervin as one of the champions of the Watergate controversy. And in that episode, he was a good person, did good things. But Sam Ervin was a segregationist senator from North Carolina who throughout his public life was a white supremacist. He did all that he could throughout most of his life to keep black people down. I mean, I'm just cutting to the chase, telling it like it was. That was his position. He didn't put it in so many words, but that was what he was about. Near the end of his political career, he embraces colorblindness. Why does he embrace colorblindness? Does he embrace colorblindness to attack segregation, which he had embraced and championed for most of his life? Oh no, he doesn't embrace colorblindness to attack segregation. He embraces colorblindness to attack desegregation. He embraces colorblindness to attack busing for purposes of integration. He embraces colorblindness to attack affirmative action. The same is true of a person who was the Chief Justice of the Supreme Court for many years, Chief Justice William Rehnquist, the predecessor of our current Chief Justice. Chief Justice William Rehnquist embraced segregation, or if he didn't embrace it, he was indifferent to it, culpably indifferent to it. But he becomes later a champion of colorblindness, but only in one context. He only becomes a champion of colorblindness, again, to attack policies aimed at advancing the interests, the position, the status of historically disadvantaged racial minorities. So, I've already said that they're perfectly wonderful people who have embraced colorblindness. There are other people who have been appallingly indifferent to racial justice who also have embraced colorblindness, but for very bad reasons. And it seems to me that should be part of the discussion. The main reason why I am against color blindness as a mantra, as a motif, as a slogan, as a policy, is that if you really take color blindness seriously, it poses a dire threat to important policies in American life that over the past 50 years have helped to undo some of the injuries generated by racial oppression in America. Colorblindness is clearly a threat to affirmative action, the idea of, on a racial basis, explicitly trying to help out historically disadvantaged racial minorities. But colorblindness is also a threat to another policy, and I'll mention this and then turn this monologue into a dialogue. There is a case before the Supreme Court of the United States right now. You'll probably learn about the Supreme Court's handling of this case in late June or early July. It's a case called Fisher versus the University of Texas. It's about affirmative action at the University of Texas. But I'm not going to really speak about affirmative action. I'm going to talk about another part of that case. In Texas, if you were in the top 10% of your high school class, public high school or private, if you were the top 10% of your class, you get automatic admission to the University of Texas. It's called the Top 10% Plan. And the reason why the Texas legislature the main reason why it created this was because they wanted to make higher education in Texas more available to Latinos and blacks. That was the main purpose behind the top 10% plan. But they wanted to do it in a way that did not explicitly say anything about race. Remember what I said about the plan. The plan says if you're in the top 10% of your class, you get automatic admission to the University of Texas. It says nothing explicitly about race. But behind the plan, the purpose of the plan, the main purpose was to give a boost to Latinos and blacks. Because, why? You might say, well, why is that? That's because in Texas, as in many places, public education in particular, is racially separate. In Texas, most Texas high schoolers, white high schoolers, go to classes with other Texas white high schoolers. And most black kids, most Latino kids in Texas, when they go to high school, they go to, mostly black high schools or mostly Latino high schools. And so the Texas legislators knew about this, of course, and they figured, well, if it was a predominantly black high school, the top 10% of the class will probably be predominantly black. This will be a way, a quote, non-racial way of allowing more blacks and more Latinos to get higher education in Texas. Thus far, many people have embraced such plans and have called them non-racial plans. But they are racial. They're not racial in form. They're not racial explicitly. But the purpose of the plan was to allow more blacks and more Latinos to get higher education. I expect in the coming years for these plans to come under attack. And if you are a strong believer in the colorblind Constitution, they should come under attack because they are not actually colorblind. They are keenly race conscious. But I think that they are good plans. I think that affirmative action is good. I think that our anti-discrimination laws are good, even though they too are race conscious. And so it seems to me that a thoroughgoing commitment to colorblindness, though well-intentioned, would have profoundly negative consequences in America, because the upshot of colorblindness, a thoroughgoing commitment to colorblindness in America, would be to get rid of reforms that over the past half century have done a lot of good in our country. Well, you all have sat very patiently, and I appreciate that. And I think I have time for some questions. And the floor, by the way, is open not only to questions, but the floor is also open to comments. And the floor is also open to objections. Because I would assume in an audience like this, there will probably be people who, disagree with at least some of what I've said. In any event, thank you very much. Floor is open. Yes.
It's my understanding that the board originally intended for affirmative action to be kind of a finite policy, I suppose. So what would be your opinion on the kind of open societal implications for innovation that our society no longer believes in that?
Great question. So, the question was, when affirmative action was begun, wasn't it begun with the idea that it would that there would be some durational limit to it, that it wouldn't go on forever, there would be some durational limit to it? And if that is so, what should the duration of affirmative action be? It's a wonderful question. It's a question very much on the minds of the Supreme Court justices. So for instance, in the very last Supreme Court case dealing with affirmative action in higher education, there were two cases actually from Michigan, case involving the University of Michigan, the undergraduate part of the University of Michigan, and then another case involving the University of Michigan Law School. The most important of those decisions was a case called Grutter versus Bollinger. It involved the University of Michigan Law School. Justice O'Connor wrote the opinion in that case in which she upheld affirmative action, but at the very end of her opinion, she spoke right to your point. She said, you know, we hope that in 25 years, there will be no more need for affirmative action. So this whole issue of what should the duration of affirmative action be? How will we know when affirmative action should end? That's very much on the minds of law professors, on the minds of, judges, justices. My own view is that I'm loath to set forth a formula for the duration. So Justice O'Connor said 25 years. There were two sorts of criticisms of Justice O'Connor that came from different ends of the political spectrum. Justice Ruth Bader Ginsburg said, well, it's going to be longer than 25 years. I mean, if you take a look at the indicia of well-being in American society, what do I mean by that? If you take a look at longevity, if you take a look at infant mortality, if you take a look at wealth, if you take a look at income, if you take a look at occupational distribution, if you take a look at education, if you take a look at housing, if you take a look at incarceration, if you take a look at anything in American life, anything, and I mean anything, who parties with who dates who marries who, anything in American life, you will see racial stratification. And it won't be a surprise. It will be a racial stratification about which we are all familiar. Is that going to go away in 25 years? No, that's not going to go away in 25 years. In fact, Justice Ginsburg said, well, let's take a look at the past 25 years. Have these various gaps gone away? No, they haven't gone away. And so it's unrealistic to think they're going to go away the next 25 years. Justice Thomas, speaking from a very different ideological position, agreed with Justice Ginsburg on this point. So I think it's a very dangerous, I would be loath to set forth a formula. My own position on this is that affirmative action should be left up to regular politics. Should be left up to regular politics. People in various, you don't have to have affirmative action. In some parts of the United States, affirmative action has been done away with. It's been done away with in Michigan, for instance. They passed a constitutional amendment, state constitutional amendment, did away with it. Same thing in California. So you can do away with it, but it seems to me it should be a matter of local politics. If people want to have it, it seems to me they should be allowed to have it. I'm very impatient and extremely critical of the Supreme Court's constitutional jurisprudence. I don't think that there is a good legal argument for the proposition that racial affirmative action is unconstitutional. The Supreme Court has created doctrine which puts a pall over the constitutionality of affirmative action, but it seems to me that's just the justices' not liking this and coming up with, legal reasons to get rid of it. But I think that they're profoundly mistaken. So I'm not sure when affirmative action would end or should end. I think there's something organic about these things. So let me draw an analogy. I don't know if this analogy fits, but there was a period in American life when on the Supreme Court of the United States there was a, quote, Jewish seat. So the first Jewish person to sit on the Supreme Court of the United States was Louis Brandeis. After Louis Brandeis, it was Felix Frankfurter. After Felix Frankfurter, it was Goldberg. After Goldberg, it was Fortas. So for a stretch, in the same seat, there was a Jewish lawyer, and it became known as the Jewish seat. Well, there came a point, I think it was after Abe Fortas. He left the seat, and a non-Jew was nominated and, took the seat. And there was a period of time when there was no Jewish person on the Supreme Court of the United States. And people might have noticed it, but nobody's sort of, it was like, shrugged their shoulders, no big deal. People mention it, but there was a time in American life when, for various reasons, symbolic reasons, other reasons, there was a feeling that it was really quite important for there to be a Jewish American on the Supreme Court of the United States. Partly as a sign of America maybe grappling with, in a decent way, with anti-Semitism. It's important for their, in this important platform, important organization in American democracy, for there, there'd be a Jewish presence, and but then over time, not such a big deal. I can imagine a time in American life in which we wake up one morning and because of change that's happened, I hope that this will be the case. I hope that this will be the case. Because change has happened, because, there's been black Americans doing this and that and the other. Somebody will say, so-and-so was elected president of the United States and so-and-so has constructed his cabinet. There's no black person in the cabinet. And I can imagine somebody saying, that's interesting. For a long period, there was always a black person as part of the cabinet, and there's not a black person part of the cabinet now. Interesting. Pass the Cheerios. Now, at that point, it's no longer salient. It's people notice it, but it's not a burning issue. Now, is that the case? No, that's not the case. The fact of the matter is, to stick with my cabinet analogy, there has been a black person in the cabinet of the United States ever since Lyndon Baines Johnson was president. Even presidents who say that they're against affirmative action make sure that they have a black person in the cabinet. Ronald Reagan always had a black person in the cabinet. The two Bush presidents had black people in the cabinet. I bet for a while now it will be the case that there's a black person in the cabinet. Because of, sort of the feeling that this is still something we're grappling with. At some point, if we're smart, and if we continue to struggle with this, and if we're lucky, There'll come a time when it's no big deal. And I would say at that time, let's let it loose.